see who you are. You are my enemy, my enemy. You are my enemy.
俺はこの国を変える。
7.01 Introduction. Hollywood dramas portray cross-examinations as exercises in pyrotechnics. The lawyer asks hostile and sarcastic questions, mixed with clever asides too. The jury and the witness gives evasive answers. Cross-examination causes Captain Queeg to reveal his mental instability in the Caine Mutiny. It rings, a confession from the defendant's wife and witness for the prosecution that she has been lying to frame her husband. Perry Mason used cross-examination as an investigative tool to search for the real murderer. This may make good theater the struggle between good and evil, but it hardly paints an accurate portrait of cross-examination. Rarely in a lawyer's career will he or she ever have to battle a scheming, dishonest witness, knowing that the witness's testimony must be broken in order to save an innocent client. If cross-examination is not usually a battle of wits between a scheming witness and a clever attorney, how should it be understood? Like direct examination, it is primarily a method of proving your case by eliciting testimony from a witness. That witness has given information on direct examination that favors your opponent, and now you must pick over what remains to find the few nuggets that favor your own theory of the case. Its success depends not on your ability to ask clever questions, but on your ability to control the flow of information so that the witness's testimony is limited to the selected items you want to bring out. Some witnesses will be hostile, some suspicious, and some defensive. None will react with gratitude when you attack their credibility. If you fail to control the cross-examination, the chances are that the witness will end up repeating the harmful direct examination and explaining away the weaknesses in it that you wanted to emphasize. On direct examination, witnesses are controlled through preparation and rehearsal. On cross-examination, however, it is usually impossible to rehearse, so you will have to rely on meticulous preparation. Cross-examination is a dangerous foray behind enemy lines. The only way such incursions can be successful is if they are carefully planned, tightly controlled, and thoroughly disciplined. 7.02 Example of a cross-examination. The next few pages contain an illustrative example of cross-examination. In a hypothetical personal injury case, Hartzig v. Roberts, the plaintiff has alleged that as he was crossing a street, he was struck and injured because of the defendant's negligent driving. The defendant claims that the plaintiff stepped out suddenly from between two parked cars. An eyewitness, Laura, won. Some of the material in this chapter was previously published in J. Alexander Tanford, Keep in Cross-Examination Under Control, A.M. J. Trial ad VV 245-1.